The RICO trial of rapper Young Thug and members of YSL has provoked renewed interest among the public as to the inner workings of the court. One of the key aspects of the court system is its reliance on precedents, previous court decisions, when deciding how to rule on current matters before the court. In this video, we will give you all the basic information you need to know in order to understand how precedents are created, how they are used, and how they are cited in legal documents. In our paralegal course, we give our students a deep dive into reading cases and understanding and producing legal citations to cases. See the link in the description. In this video, we will use court documents from the YSL case to help you understand the basics. The first step to understanding precedents is gaining an understanding of the court system. Both federal and state courts are composed of three basic levels: the trial level, the appeal level, and the Supreme Court level. As of the time of this video, Young Thug and YSL are currently on trial at the trial court level for RICO-related charges. A precedent is a ruling on a legal issue which comes from a higher court and binds lower courts. Lower courts must rule the same way as it relates to that particular legal issue. This is why trial courts typically cannot create precedents, as they are the lowest levels of court, and there are no courts beneath them that they can bind. But as appeals courts are higher than trial courts, their legal rulings can bind trial courts. And as Supreme Courts are higher than appeals and trial courts, their legal rulings bind all courts beneath them. Here it is important to specify what constitutes a legal ruling. A legal ruling is not the outcome of a court case. A legal ruling is a judge's decision about a specific question which occurs during the case. For example, in our paralegal class, we take up the definition of DUI in the Virginia DUI statute. The Virginia DUI statute says, "It shall be unlawful for any person to drive or operate any motor vehicle, engine, or train while such person has a blood alcohol concentration of 0.08% or more by weight." Notice, the statute says it is unlawful for a person to drive or operate a motor vehicle. As the term operate is not defined within the statute and can lead to confusion, the court must interpret the meaning of the term operate and make a ruling as to what operates means within the DUI statute. This ruling at the trial court level will only affect the trial in which the judge makes the ruling. It will not affect any other trials. However, should the defendant appeal the ruling, the judge's definition of the word operate, to the appeals court, at that point, the appeals courts will either agree with the trial court definition of the word operate or will provide its own definition. Either way, as the appeals court is higher than the trial court, the appeals court definition of the word operate will bind the trial courts going forward. From that appeals court ruling and going forward, trial courts will be bound to use the appeals court definition of the word operate as it relates to the Virginia DUI statute. Should the matter be successfully appealed to the Virginia Supreme Court, at that point, the Virginia Supreme Court will make a ruling as to the definition of the word operates, and that definition will bind all courts, both trial and appeals courts, in the state of Virginia, going forward. As you can see, generally speaking, court decisions at the trial court level do not become precedents, as there are no courts beneath the trial level that the rulings could bind. The YSL RICO trial is currently at the trial court level and is unlikely to generate any precedents during the trial itself. However, attorneys for YSL defendants have appealed certain rulings that the judge has made to the Georgia Supreme Court, and the rulings the Supreme Court makes in relation to these petitions will likely create new Georgia law. In particular, attorney Brian Steele and other YSL attorneys are asking the Georgia Supreme Court to remove Judge Ural Glanville from the trial. The YSL attorneys assert that Judge Glanville erroneously allowed a secret ex-parte meeting between himself, witness Woody Copeland, and the prosecution, unbeknownst to the defense. The defense is requesting that the Georgia Supreme Court rule this ex parte meeting as being judicially inappropriate. The stakes are high. If the Georgia Supreme Court rules that the ex parte meeting was inappropriate, then Judge Glanville will likely have to step down, and future judges will be put on notice that such meetings are not tolerated. However, if the Georgia Supreme Court sides with Glanville, that could signal to future judges that having secret meetings with the prosecution and sworn witnesses without the defense's knowledge is appropriate. So, how do you find precedential rulings, and how do you know them when you see them? During the YSL case, both the attorneys and the judge frequently cite legal precedents. For example, take a look at this exchange between Judge Glanville and attorney Brian Steele, in which they both cite a precedent set in the case Baptiste versus State.
Bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the State.
I have read Baptiste versus State. I've read all the cases that I believe are applicable. Best I can.
As a side note, if you would like to listen to an audio reading of the Baptiste case and decide for yourself which side is citing it correctly, see the link to the Baptiste case in the description. Looking at the Baptiste case documents, it becomes clear that not only does Baptiste serve as a precedent for current cases, but Baptiste itself also refers to many court cases that were decided prior to Baptiste, which served as precedents for the Baptiste case. This is to say, judicial rulings accumulate over time and form a body of law called case law. Case law is nothing more than the accumulated mass of judicial rulings which are currently in effect at any given time period. Remember, these will primarily consist of appeals and Supreme Court rulings on the various matters that occur during legal cases. Finally, we will explain all the information that is contained in a legal citation. In order to understand the format of legal citations, it is important to understand the law book system, as can be seen in this video. Have you noticed that the court documents are filled with these legal citations? These law books are the key to understanding the citations. These books are called reporters and contain appeals and Supreme Court decisions. As we learned earlier, these decisions contain rulings that create precedents. That is why it is important for lawyers to have access to these rulings so that they will be able to determine the most current rulings relating to matters that are important to their case. When looking at a legal citation, first, you see the last name of the parties in italics. When a government or organization is involved in the case, instead of a last name appearing, the name of the government or organization will be included. There are special rules that determine how to refer to governments and organizations. We cover these rules in our legal citations and blue booking workshop, but will not cover them in this video. After the party names comes the volume number of the reporter. This is referring to the physical book in which the case is printed. Next comes the name of the reporter. Then comes the page number on which the case starts in the reporter. Finally comes the page number on which the ruling can be found. The year the case was decided is added last. As you can see, legal citations are referring to cases printed in books. Take this book, for example, Maryland Appellate Reports, Volume 258. As you can see this case printed in this reporter, we have the case name, Housing Opportunities Commission versus Adebayo. We have the reporter number, 258. We have the name of the reporter itself, Maryland Appellate Reports. We have the page number on which this case starts, 137. Notice that we are looking at page 144, so apparently this case starts on page 137 and continues to at least 144. And we have the year the case was published, 2023. You now have the basic information you need to understand the legal precedents the attorneys and the judge in the YSL case are using. You also have information about the legal citations found in the cases and pleadings and where they come from. If you would like to continue to learn about the U.S. legal system, Subscribe to our channel and watch some of our other videos. Also, contact us if you are interested in paralegal education and training.